Yeah, thank you very much, Yannick, for moderating the previous session, and thank also again the speakers of the previous session. I think we okay. I think I'm a moderator now again. Yeah, thank you again for the previous speakers for this very interesting session, and also the introduction to the Digital Services Act, on which we now in this session will further elaborate on. I think the panelists of this session 3 are still to be added. So probably let's wait a quick second. Welcome. Welcome, Professor Flesner. And I think the commentator is still missing, but I assume we can also start. In this session, we are discussing Chapter 3 of the Digital Services Act proposal, which sets out the due diligence obligation for a transparent and safe online environment. This is to be handled in 5 sections, and in this session we will focus on the first 2 sections of this chapter, which mainly focus on the obligation to establish a single point of contact to facilitate communication between the member states authorities and the Commission, and also to designate a legal representative to the Union in case there is no establishment in the European Union of a company. And in section 2, there are obligations laid down which are applicable to only providers of hosting services. And in this point, we will observe the development of the notice and takedown procedure. So to first introduce the first speaker, which will focus on section 1 of this chapter, is Teresa Rodríguez de las Heras Ballell, which is an associate professor of commercial law at the University of Carlos III in Madrid. She is also a member of the European Union expert group for the Observatory on the online platform economy, and also has been a project member of the European Law Institute project for the EU model rules on online intermediary platforms. Furthermore, she is a member of the European Commission expert group on liability and new technologies, and also a delegate for Spain before UNIDROIT. Beyond that, she's also legally advising nationally and regional governments in drafting of new legislation on electronic commerce and digital space, and also privacy protection. The second speaker of this session will be Christian Twigg-Flesner, who is a professor of international commercial law of the University of Warwick. And like Miss Teresa de las Rodríguez de las Heras Ballell, he's also a member of the European Law Institute, and like her, he's also elected a council member of this period of the Council of the European Law Institute. He has extensively published on EU consumers and contract law, and one would think of the most notably of this benchmark work on rethinking EU consumers law together with Howells and Williamson. At the moment, his particular focus of his current research is on the implications of the digital economy. And on that, he also delivered a UK perspective on the legal and policy responses to online platforms in the Blarock-Schmidt-Kessel-Erler publication on platforms. He is also the author of the very recent ELI guiding principles for updating the EU product liability directive for the digital age. And Last but not least, we're also very happy to welcome Aleksandra Kuczerawy from the KU Leuven. She also did extensive research in the area of intermediary liability and in human rights, with especially regard to the freedom of expression, which already was mentioned a lot before in the previous discussion. And in 2020, she was also appointed a member of the Committee on Experts on Freedom of Expression and Digital Technologies on that. So she has also been dealing on questions about reopening the e-commerce directive, and has also organized a conference herself at the European Parliament on content moderation practices, which also had been addressed in the previous discussion already. So now, with this being said, I will immediately hand over to Professor Rodríguez de las Heras. So please, if you could share your screen and begin with your presentation. Yeah, seems to work so far. Then the floor is yours. Thank you.
Okay, good afternoon, Jacob. Thank you very much. I'm delighted to share this panel with my dear friend and colleague Christian, and with Aleksandra and you, Jacob. I'm very happy to have the opportunity to share with you some thoughts on this provision, the fascinating DSA that is going to guide us to the new European Union digital law legal framework for the next year. At the first sight, taking into account that I'm going to focus on Chapter 3, Section 1, that is covering Article 10, 11, 12, and 13, at an isolated level, let's say at a first sight, the first impression you get is that probably these legal provisions are focused on more formal, a bit procedural obligation. This obligation seems to be a little bit more descriptive, purely transparency and reporting obligation. However, my idea is try to contextualize this obligation in the framework provided by the scope of the DSA in general, and trying to show how, when we are getting closer, we realize that these provisions are indeed crystallizing many important policy goals of the DSA. And even more, we can immediately realize that we could unveil from this legal provision some important elements that help us to understand the interaction of the future DSA with other important instruments that are configuring the legal framework for the digital economy. So let me just start from the first idea about the scope. Chapter 3, Section 1 is very clear, very explicit from the very beginning that in relation to the personal scope, within this very interesting multi-tier legal obligation system that the DSA provide, this section in particular applies to all intermediary service providers. That means that they are going to be the minimum. That is going to be the basic for all the intermediary providers to add, in case that you are an online platform, a very large online platform, you are going to add above this particular basic obligation, other obligation as well. So that is very interesting, because in a way it's given us what is this minimum core that the European Union consider absolutely fundamental to capture all these intermediary service providers. The other element that I would like to discuss with you in a minute is how this obligation are showing the particular connecting factors that the Commission, that the European Union has chosen are the most convenient, the most definitely adequate in order to define the scope of application, the territorial scope of application of the DSA. And we will see that this element of the point of contact and the legal representative, indeed, they are articulating a very particular connecting factor system for the purpose of defining the scope. So let me just go article by article analysis, and we can start with Article 10 and Article 11 together, because even if they are clearly describing two different mechanisms, two different techniques, the point of contact and the legal representative, indeed they are, in my opinion, providing a two-level, if we wish, two-level system for the purpose of ensuring the compliance and the enforcement of this DSA. For me, these two provisions that are clearly procedural in that regard, because apparently they are not defining too much how is going to be the running of the activity by this intermediary. However, they are representing a very important policy goal, or if you wish, a policy aspiration underlying the DSA. And I have used this word or this sentence. It's an effort, it's an attempt to localize the delocalized in the platform economy. The DSA is clearly trying to grasp how to apply a naturally territorial-based regulation to a platform that is naturally delocalized, that is naturally global. How to find the proper bridge between these platforms that are providing services at a global, delocalized level, how to connect and tend the bridge with the particular regulation without committing two mistakes. The first one is to raise a barrier that would be a tremendous risk that the DSA have to avoid. We are regulating in a way that is creating disincentive. We are creating barriers to entry. That is not definitely a good way to proceed. And the second risk that we always have to minimize to the maximum extent when we are regulating the digital economies, how can we guarantee that the rules will apply to those kind of services and activities that we are targeting? How we guarantee that the interests that we want to protect are indeed duly protected, avoiding a very easy evasion, a very easy eluding by the platform of that particular regulation. How to do that? I think that this combination of point of contact that are simply some data, that are contact data, contact detail. We are not talking about any specific establishment or any specific physical connection with the European Union territory. We're talking about digital contact detail for the purpose of interaction, for the purpose of guaranteeing that is not going to be a gap, a vacuum when the particular authorities want to enforce or simply notify or communicate with these platforms. That is Article 10. But Article 11 is more than that. Article 11 tried to make physical, if I may use this word, materialize this territorial connection with the Union. And therefore, even if, of course, these intermediaries, including platform, don't need to have an establishment in the Union, that is absolutely clear, and however, provide and offer services to the Union, however, they are expected to nominate, designate a legal representative in the Union. In one of the member states they are offering the services to. Why is that so important? Because we are clearly defining a very important connecting factor for the purpose of compliance, for the purpose of enforcement, and for the purpose of jurisdiction as well. That provision has to be combined with the final provision of the DSA, where it is established, it is provided for who or which member state has jurisdiction over a specific provider in case of non-compliance or in the need of enforcement of a specific penalties or sanction arising from the regulation. That is very important. But the legal representative that is going to be added, so in addition or alternatively instead of the provider, no matter where this provider is located, might be also liable in case of not compliance. So as you can see, and this is very interesting, we have an addition of potential liabilities because this possible liability or accountability of the legal representative is not replacing or substituting the liability that the provider might be directly might be held in the case of the DSA. But probably there is also another element that is interesting, at least to remark very briefly, is that this legal representative that is going to be designated in the Union for the purpose of the DSA, it is not an establishment of the provider. That is very important because if this obligation is essentially procedural, is for the purpose of ensuring or facilitating the enforcement, that should not entail an obligation of the provider, for example, to redesign the specific taxation strategy that this provider has decided to deploy for the purpose of running the activity in Europe. So when this provision says that not entail an establishment in the union, that might be relevant, for instance, for the purpose of taxation. That is not going to be considered necessarily a permanent establishment for the purpose of taxation. Let me just add another combination of internal combination of articles. We could combine this pair of Article 10 and 11 also with the Article 2, and in particular 2 of the definition used by the DSA. The definition of offering services in the union. That is probably the most interesting connecting factor, the connecting threshold defined, formulated by the DSA for the purpose of ensuring what is this natural, this substantial connection that that particular platform or in general intermediary has with the union. And it's indeed the legal justification that make these rules naturally, legitimately applicable to this provider. You are offering services in the union, either because you have an establishment, so it's a location, or maybe you don't have an establishment, but, and this is the key, you have a significant number of users in one or more member states, or you are targeting the activities toward one or more member states. This idea of the stream of commerce. This idea that there are factor, criteria, elements that prove that you are indeed intentionally targeting or directing or addressing these services to that particular member state. So in a way, there is an expectation. It's not unpredictable, it's not unexpected for this provider to be subject to the provision of this regulation. That is very important, this idea of legal certainty or legal predictability. And another element that is also very important to take into account is that it is applicable, as I mentioned before, to all intermediary service providers as defined in Article 2. So taking that into account, please, let me go just in a moment to put a little bit more in a broader context this scope of application of the DSA and try to compare this connecting factor in the DSA, in the DMA, and also in the already enforced regulation platform to business. As you can see, when we conceived electronic platform, that is indeed what is behind intermediary service provider. I know that not only because we're talking about Merconduit and caching and hosting, but at the very end, what we have in mind is this very fascinating structure of a platform. What that means that the provider, in most of the cases, is facilitating the contact within 2 or more users. So if the establishment of the gatekeeper for the DMA or the intermediary service provider for the DSA or the service provider for the regulation platform to business, in all the cases, the establishment of the provider is irrelevant. So what are the connecting elements? What are the hangs that we can take into account for the purpose of applicating the regulation? Always the user community. These are the pillars. These are the connecting factor. In the case of the DMA, as you know very well, we have the idea of business users established in the EU and users established or located in the European Union. Very similar formulation in the case of the DSA, recipients of the services established or residing in the European Union. Is, by the way, interesting to see how the DMA used located and the DSA used the term residence or establishment. Is a stronger bound, is a stronger link, I can see. As for the regulation for platform to business, that is going to be applied as a lex specialis in comparison or in combination with the DSA, we have exactly the same logic, with the only difference that in the case of the regulation, the user has to be consumer. However, they are not consumer in the case of the DSA or the DMA necessarily. Let me go very briefly to the third article that I would like to describe briefly. This Article 12, at the beginning, at least for me, seems a little bit descriptive. is purely descriptive. It's saying, okay, you intermediary service provider, you have to establish, set out, describe very clearly, legible, not ambiguous in your terms and conditions, in your policies, procedures, measures, and tool, how you monitor, how you moderate the content, what kind of restrictions you can apply, what kind of remedies you can apply and penalties in case of violation of the law or violation of the terms and conditions. Seems to be very descriptive, nothing different from what we already have in the regulation platform to business. However, I think that this article is a beautiful provision because encapsulates the idea that is underlined behind the DSA, that we are not regulating anymore simply service provider. We are regulated private regulators. That is completely different. When we are regulating service provider that in the running of their activity, what they are doing indeed, as you can see in my graphic here, what they are doing is they are creating a self-regulated environment. And that is the reason why they can't establish procedure, policies, terms and conditions. They define what is permitted and what is not. They define what is illegal and what is not. They define how they are going to moderate content. They define what are the policies of penalties. They decide when they can, for instance, close an account, when they can demote a specific content. So this idea of regulating what I like to define as private legal system is one of the most beautiful key messages of this particular Article 12. And let me please conclude with a general description of Article 13. Again, Article 13 is an article that simply, but maybe not so simple, simply set out a transparency reporting obligation. Again, the provider has to report. The provider has to inform of these particular issues, this particular item. What can we see here? We are not seeing much about the substantial nature of the obligation, but this article reveals a lot about what we have behind. Because what we can see here in this Article 13 is that excluded the micro and small enterprises, excluding that. But what we can see here is that this platform, these providers, they have to notify, they have to report information or data about the following items: number of orders or notices or at own initiative removal, time for action, types of illegal content, what are the bases on which they have decided to remove that content, the law or the terms and conditions, what kind of measures they have applied, not only removing or disable access. We provide a lot of flexibility here, maybe reducing the availability, maybe reducing the visibility or the accessibility is even more effective than simply removing. And why is more effective? Because it's more easy to strike a balance with other rights, with other interests. If we are not removing directly the illegal content or the content that violates the terms and conditions, we are simply minimizing their visibility with a demoting, for instance. Probably the impact on the free speech and other fundamental right of the party with the interest is probably less damaging, is less strong if we use these kind of measures. So this article is saying us a lot. Is giving us, in my opinion, the playing field within these providers can play. Within these providers can define the different content moderation policies they want to implement. They are defining us, for example, what are the different sources where these orders could come from. Not only orders from authorities, but also notices from users, but also, and this is very significant if we compare that with the Electronic Commerce Directive, at own initiative of the providers themselves. So there is a beautiful also balance between, there is still not an obligation to general monitor, but at the same time, the DSA promote and encourage these providers to be proactive if they can. So this article that I conclude right now, this article that at the first sight, they are not fascinating, I might say. They are not fascinating because they are simply making reference to this kind of obligation that seems to be more regulatory, or if you wish, bureaucratic, than purely substantial. At the very end, they are a thought-provoking mirror that lead us to go into other obligation as set out by the regulation. So that would be for me the message that from this initial analysis, initial assessment of this chapter 3, section 1 might really deserve further discussion with you. Thank you very much.
Thank you very much, Professor Rodríguez de las Heras, for this very interesting presentation. And thank you also for addressing the scope of application and also with regard and in relationship to the DMA and also the P2P regulation, which also Sebastian mentioned already at the beginning of this conference. So now I will already hand over to the second presentation of Professor Twigg-Flesner. Yes, perfect. I saw that the screen sharing is already functioning. Then I can, yeah, please go ahead.
Thank you very much indeed. Thank you for, first of all, inviting me to join the panel of speakers. And I always feel slightly anxious when I follow Teresa, because I'm always amazed by those very clear and thought-provoking explanations. So what I have done, as you will see, I've tried to compete with the graphics a little bit and the nice diagrams. So I knew Teresa was doing diagrams, so I had to follow, look forward to some diagrams. However, this isn't working, which is a good start. Here we are. My first slide is not a diagram, just to be old-fashioned and traditional. What I will do is give you a very brief overview, first of all, of the idea of illegal content under the DSA. I won't dwell on this for too long, but it's important, I think, to just be aware of the idea of illegal content, because the notice and action mechanism, which is the main element of my presentation, very much builds on the idea of illegal content. And I will also say a few words, but not as much, about the statement of reasons required under Article 15. So let me just very briefly say a few words about illegal content as defined in Article 2G of the proposal. In essence, it's an incredibly broad definition. Illegal content is any information which is not in compliance with union law or the law of a member state. So in essence, anything that somehow doesn't comply with any kind of legal rule, whether it is criminal law, constitutional law, private law, falls within that definition. Now, this information can in itself be illegal, not be in compliance with union law. And as recital 12 tells us, this can be things like hate speech, terrorist content, unlawful discriminatory content, and I would hope also things like impersonation or identity theft, which are a big problem on online platforms. I don't know how many of you have been the victim of identity theft. I certainly have been, where people are pretending to be me on all sorts of weird and wonderful platforms. So this is probably something that I would like to also regard as being illegal in itself. But also it can be illegal by its reference to an activity which is illegal or has some kind of legal framework behind it. For example, the sale of products or the provision of services. And indeed, as recital 12 makes clear, it can be a lot of different things. It could be sharing images of child sexual abuse. It can be online stalking, sale of counterfeit goods, which was touched upon in the previous session, the non-authorized use of copyright protected material, and indeed more generally infringing consumer protection law. And there's this kind of strange bringing together of lots of different things under the heading illegal content. So whereas we might have thought that the focus would be primarily on harmful content, what illegal content is really dealing with is anything that is violating any kind of legal rule. And as I noted in passing already, it doesn't matter what the precise subject matter or nature of the law in question is. And it's really important to bear in mind just how broad the notion of illegal content is, to then understand how Article 14 fits into this broader picture of controlling what is on platforms and what comes off platforms. In dealing with illegal content, we have a number of different routes of attack, and we've heard about some of them already. We have the voluntary own initiative investigations under Article 6, possibly driven by Article 12 constraints. We have judicial or administrative orders under Article 8. Then we have my main focus, which is notice by individuals or entities under Article 14, and the trusted flaggers, which can also use the Article 14 mechanism to point out that there is illegal content on a platform. So let me now come to the gist or the meat of my presentation, the notice and action mechanism under Article 14. The mechanism is in fact available to any individual or entity, including trusted flaggers, but anybody who points out that there's illegal information on a platform can actually take advantage of the notice and action mechanism. It is not confined, therefore, to users of the platform in question. It can be somebody who's not a user, but who is affected by the illegal content. But any of these people, if they identify a specific item of information, so it has to identify, for example, a specific post or a specific picture or similar, it can't be a general, this particular person is posting illegal material. It has to be the identification of a specific item of information, which the individual or entity considers illegal. So it's not a requirement that the item necessarily has to be illegal. It may be possible that they are mistaken that the item is illegal ultimately, but if they think that it is illegal, or they have good grounds for believing it is illegal, then they can take advantage of the notice and action mechanism. I think it's important that the threshold is lower here in the sense that it's not necessary to be sure that the information is illegal, because not everybody will necessarily be fully versed with all areas of law, and they might simply suspect that there is a breach of law here, even though an expert would maybe identify that there isn't a breach. But it's important to flag that there is a problematic content here that certainly is likely to be illegal. They then use the notification mechanism and notify the provider of the hosting service. So what about the notification mechanism itself on Article 14? There are a number of requirements raised in Article 14. It must be easy to access, which is a simple enough term to state, but it could actually be quite a complex one to operationalize. Why do I say this? What do we mean by easy to access? Do we mean it's technologically easy to access? Is that this simple requirement? Is it easy to access in the sense that it's proximate to the information of concern? Or is it on a completely different part of the online platform, for example? Does it even relate to things like equality issues, or are they entirely separate? Could it be a problem if, for example, it's not so easy to access to someone who's got, I don't know, perhaps a special educational needs or similar? That's an interesting question, I think. What exactly does easy to access mean? And similarly, user-friendly could raise comparable issues. What exactly is required for something to be truly user-friendly? It also should allow for exclusive electronic submission. That doesn't mean that it has to be purely electronic submission, but it should at least be possible to make the submission entirely by electronic means. The mechanism then has to allow the notices which are submitted to be both sufficiently precise and adequately substantiated. Now, the burden is on the hosting services provider, the online platform, to ensure that the notices can be sufficiently precise and can be adequately substantiated, but there's not a prerequisite on the person making the submission that the information they provide is actually sufficiently precise and adequately substantiated. But at least they should have the opportunity to be as precise as possible. And this may in part be because of the consequences which flow from notification. Ever since the L'Oreal and eBay judgment, we know that information which would allow a diligent economic operator to identify that content is illegal, that this kind of crosses the threshold whereby the liability exemption may be lost. And I'll say a little bit more about this in a moment. So, important thing to note here is the mechanism has to ensure the provision of sufficiently precise and adequately substantiated information. In other words, we shouldn't have a mechanism whereby a platform makes it very difficult to actually raise the reason why something is illegal content. They have to make it as easy as possible. And then there's much more detail in Article 14 too about what sort of elements the mechanism should have. In particular, it should be possible to state why the information is considered as illegal content. So there might be a whole range of different reasons that could be given. A clear indication of the electronic location has to be given. And I suspect things like the notify or flag this post on Twitter and Instagram and similar pages would be enough because it would be connected to the post in question. The possibility of allowing the person making the notification to give their name and email, because that also has certain follow-on obligations. But note that any of the offenses under the Child Sexual Abuse Directive do not require the provision of names or emails of the person submitting the complaint. And finally, a statement confirming the good faith belief that the notice is accurate or complete. I noticed there are no particular sanction envisaged as such at this point, but of course we have the possibility of dealing with repeat false notifications through Article 22 and further along. There's actually not a great deal of detail in Article 14.2 about the precise nature of the notice and action mechanism. But in Article 34, it is highlighted that the Commission will encourage the development of industry standards to develop a standardized notice and action mechanism. And I think it's this interaction between spelling out broad objectives in Article 14 and then hopefully relying on more detailed industry standards that makes this a really important combination of regulation and a degree of self-regulation. Obviously, there's no obligation to follow industry standards, but I think following an industry standard which has been developed under the guidance of the Commission might actually be a good way of showing that there's compliance with Article 14. So this is an important aspect as well, the interaction between the legal requirements in Article 14 and potential development of industry standards. What happens then once a notice has been received? A number of things are triggered by this, which again is quite complex. First of all, if the notice includes all the elements stipulated in Article 14.2, the ones I just mentioned on the previous slide, this in fact makes or creates this fiction that the hosting services provider is now deemed to have actual knowledge or awareness of the content and of the illegality of the content. And that means the Article 5 liability exemption no longer applies. So once they know, if no action is taken, they might incur liability because they can no longer rely on the Article 5 liability exemption. In addition, the hosting services provider must confirm the receipt of the notification promptly, and at this point, crucially state whether automatic means are used for processing. And we've discussed in the previous section why automated means might actually be used quite widely because of the sheer volume of notification, which certainly many platforms will receive undoubtedly. There's then the process of dealing with the notification, and the hosting services provider has to process the notice and take a decision on the notice, whether that will mean no further action or blocking the content or going beyond this. But whatever decision is taken has to be taken in a timely, diligent, and objective manner. Now, again, these are fairly broad requirements. Timely, as we saw earlier, may result in a number of questions. First of all, clearly there's no fixed timescale envisaged here. So it's perhaps not as difficult as a national law which requires a 24-hour turnaround, which is a very strict turnaround. The timeliness may well depend on the type of illegal content which has been raised. For example, if it is a live broadcast of a harmful event on a streaming streaming platform, I think action has to be taken very, very swiftly, and not doing so could be problematic. I suspect if it is a minor violation of consumer protection law, the timescale might be a bit more generous and not require prompt action in quite the same way. It might also depend on how many notifications on the same issue have been received, for example. That might also encourage a speedier action being taken by the platform. And the reference to objective manner could again have a number of implications. One thing that springs to mind is immediately that people should not be given preferential treatment on the platforms. If there's certain users, they shouldn't be allowed to get away with things for longer just because they might have a certain high profile. maybe a former president of a large country springs to mind who might have been a contender here. And then comes the decision. A decision is taken by the hosting service provider, which can be to disable the content, it can be to remove the content, or it can be no further action. Whatever it is, the hosting services provider under the Article 14 procedure has to notify the person who submitted the complaint to raise the illegal content of information posted without undue delay, and also inform about redress possibilities, particularly, I suppose, where the platform has declined to take any further action, because there needs to be some kind of additional follow-on step. For example, if the platform claims, as happened in my case, that they can't do anything about somebody pretending to be me, which was, it would have been nice to have known what I could have done by way of follow-on at that point. Okay, so this is how the notification mechanism works. It all sounds very straightforward. The notification comes in, it has an immediate effect, then we have to wait for a decision, and then the decision is notified, but it's incredibly complex to operationalize, of course, incredibly complex. There are so many variables and vagaries in this. And of course, the worrying thing is how automation and the desire to comply speedily by relying on automation can have the effects we discussed already in the previous panel, where we talked about the idea of overblocking and a rapid takedown, which would certainly be a problematic issue. Let me turn to Article 15 and the statement of reasons, which must also be given by a hosting services provider. The trigger point for this statement of reason in Article 15 is that the hosting services provider has decided to remove or disable access to information. Now, this decision is not just motivated by an Article 14 notification. It can be for any other reason, including, for example, a failure to comply with the terms and conditions under Article 12. So it doesn't have to be necessarily just in response to a notification of illegal content. So Article 15, to some extent, is separate in terms of its scope from Article 14. Article 14 is a particular procedure, but Article 15 is actually triggered in a wider range of instances. Where the decision has been taken to remove or disable access to information about that decision must be given to the recipient of the service who provided the information, or in everyday language, the person who posted it. And this statement of reasons has to be clear and specific on a number of things. So again, we see this idea that things have to be presented with a reasonable degree of precision. What else does Article 15 say about the statement of reason? There are a number of things that come together. It has to be clear and easily comprehensible. And here, of course, the immediate question is judged against which sort of standard? Because the people who might have presented or posted the illegal information online, or indeed have violated the Article 12 terms and conditions, could be a business, it could be a public figure, it could be just you and me. We might have posted something which turns out to violate community guidelines, or indeed could potentially be illegal. It happens that we occasionally get things wrong, I suppose. The point is clear and easily comprehensible to whom? And therefore, does this mean that automation might run into difficulties if the automatic mechanism doesn't adapt, if necessary, to the type of person which has put the illegal content online in the first place? In addition, the information in the statement of reason has to be as precise and specific as is reasonably possible. And the number of items of information are required under Article 15, which need to be included. First of all, it has to be made clear what's happened to the information. Has it been removed altogether? Has it been deleted, in other words? Or has access to the information been disabled? This might be, for example, possible because, I don't know, you can perhaps, on certain photo sharing websites, you can, for example, specify whether the content is publicly available or whether it should be restricted because it contains perhaps some inappropriate images or nudity or whatever. And therefore, access might be disabled temporarily to allow the settings to be adjusted by the user. Access might also be disabled only within certain territories where the content is regarded as illegal, whereas it might not be regarded as illegal throughout the entire European Union, because it may, for example, have been a violation under national law. There has to be information about the facts and circumstances which were relied on in reaching the decision, and in particular, whether this was due to an Article 14 notice, whether by a trusted flagger or by some single individual or other entity. Where automated means used in detecting and or identifying the content and or in taking the decision. Was the entire process automated? Was only the decision automated following an Article 14 notification, for instance? Again, this has to be made clear so the person knows perhaps whether or not there might be a ground for complaint. We all know that sometimes automated mechanisms are a bit too overeager and remove, quite valid and legitimate posts. So there's a basis for challenging the decision if it was taken by automated means. And therefore, these redress options which have to be presented, whether they're internal, out of court, or indeed judicial, are also an important reference point when somebody is told that one of their posts has been removed or access disabled. There are then two individual provisions regarding the information to be given. First of all, if the decision was based on illegal content, there has to be a reference to the relevant legal ground given and why information is illegal content. So whilst an Article 14 notification relates to information which is considered to be illegal, if it is removed because of the illegality, now there has to be a clear legal ground stated. So this kind of one level up from what's required to make an Article 14 notification. On the other hand, if the information was incompatible with the terms and conditions of use, then there has to be a reference to the relevant guidelines, I suppose community guidelines or similar, as per Article 12, to highlight why there was a failure to adhere to the terms and conditions. And then, in addition to all of this, the decision also has to be publicized and included in a commission database. There will be this massive database which will spring up and grow rapidly. It'll spread faster than the coronavirus ever did by having all these notifications entered into this database. So I hope the commission is prepared for all its servers to be swamped, and I'm willing to take bets whether you need more computing power for this database than for the Bitcoin blockchain, but we'll no doubt have a discussion around that in due course. I know I'm going quite fast because I had a lot to cover and I want to leave some time for discussion. So let me very quickly wrap up. What we are seeing in Article 14 is the much demanded introduction of a standard requirement for a notice and action mechanism. That will now clearly happen. And it might indeed be standardized further by having industry standards refining the basic requirements in Article 14. Ultimately, however, the technical implementation of the mechanism is left to individual hosting services providers. They can either follow the industry standards which might evolve, or they can decide to go their own way, as long as they meet all these different requirements in Article 14. That's the crucial overriding concern. And as has already been touched upon, first of all, because of the broad notion of illegality, we're clearly occasionally straying into the area of consumer protection, and whether that's a good idea or not is debatable. But there will also be the overlap with other mechanisms in regards to consumer protection. We already discussed the consumer protection enforcement regulation earlier. It might also be that an individual platform user might have a remedy under Article 8 of the Digital Content Directive by saying that the hosting service is not in conformity with the contract because the notice and takedown mechanism is perhaps not working or is not available as expected. So if it's not done properly, there could be this sideline private route for challenging the way a platform has designed its notice and action mechanism. So I hope I haven't gone too fast. I know I had a lot to cover, but I hope there's time for a good discussion now in the remaining, 20 minutes or so. Thank you very much.
Yeah, thank you very much for your presentation and showing the importance of these two articles. And I think we got a good impression on how crucial this new notice and action mechanism is. I will now hand over to Dr. Kuczerawy to comment on the two speeches. Yeah. Do you also would like to share your screen, or?
To be honest, hi, first of all, thank you so much for having me, and thank you for wonderful, informative and passionate presentations. I don't have any slides, actually, since I was just asked to comment, but you will have to stop me because I'm supposed to get 5 minutes, and I do have thoughts on the DSA in general. So just wave at me when you want me to stop.
No worries. We can start with the comment, and then we can lead over to the discussion as well.
Okay, so yes, that was really very interesting and very informative. I will just say a bunch of things. It might seem a little random, but I'll just go article by article. But I think I'll go immediately to Article 12, because I think that's where I mainly got really interested. And I think also in relation to the whole discussion of the scope. And I think we heard, that the general idea was to focus on illegal content. And as Christian was explaining, that is actually a very broad term here. And not so much on harmful content, right? I think that is very clear that this is a dangerous area when we talk about possibly limiting speech expression that is harmful, but is not actually illegal. So when you would have any legislator or state acting against this kind of content, that becomes a tricky situation, because we have to remember, if you look at Article 10 of the Convention of Human Rights, that speech that is offensive or defamatory or shocking is still protected speech. So that it is difficult to delineate at which point, and is it platforms that are actually best to make the decision. Right now, I think with pandemic, especially, that, we have certainly a whole new level of harmful content, but still, is it for platforms to decide if somebody challenging or questioning certain information on medical advice coming from official sources, does that actually is enough to start censoring this type of speech? So for me, the fact that it's focused on illegal content is good. We have also the discussion about hate speech. I think this is something that, it is easily thrown into the basket with illegal content, but this is also a very broad term, and hate speech in the understanding of the convention, that is indeed speech that is not protected. But again, you can have offensive comments, and I think especially politicians are very quick to assess something or accuse comments that they don't like as hate speech, but it's not actually that easy. So for me, the fact that, we want to focus on illegal content, that's good. But at the same time, Article 12 actually leaves a door open for adding all sorts of different decisions by platforms, which then can be indeed broader. So, they do have a power to decide what kind of content they do or do not want on their platform. And that is actually, that makes sense, right? We don't want, I think Jan mentioned that in the previous session, that every type of content that is legal will have to be hosted. The DSA definitely does not introduce any must-carry obligations. It allows platforms to decide. I think a very good example here is that if you have a platform for cat owners and somebody starts putting dog pictures, well, that is certainly not illegal, but if a platform decided on a certain profile, well, they can make such decisions. That is also freedom to conduct business here. So I'm ranting a little bit, sorry. This is, so for me, that is what Article 12 still allows platforms to decide. And I think Christian mentioned, that a certain president of a big country being blocked, whether that would be on the basis of a notification in Article 14 or on the basis of Article 12 as a violation of terms and conditions. We heard discussions whether platforms should be allowed to have some flexibility in how they apply their rules, right? So content that would be immediately blocked if I wrote it, but it's tolerated if it's written by a president. And I think that Article 12 actually still allows that, because it says that, the application of these terms and conditions, let me see, they use word diligent. It should be applied in diligent, objective, and proportionate way. So, that proportionality there, you can still say there is certain newsworthiness factor if it's a president or another politician writing it. So there is still, there is enough flexibility. So for me, this is interesting because, okay, it is also about harmful content or other types of content that platforms do not want. But they can still apply it as they see fit, let's say, according to circumstances. So that's I think, very interesting about Article 12. What Teresa said, that it's regulating the regulators, that it's the self-regulators. That's true. Although for me, one thing that we have to remember is that, well, when we say self-regulation, they're not regulating themselves, they're regulating us and our speech. So, or other rights, right? If they decide to leave content that it's violating privacy. So, those are conflicts about fundamental rights that we are asking platforms to make decisions about. And I think that has been already said today several times, that those are not easy decisions in any case. And then we have the additional element of scale. So there are certain compromises, I think, that have to be made here. And I think DSA is trying to get that. And for me, that certainly good element is the addition of safeguards. That can, so it's not about regulating speech, but it's about regulating the process. The platform wants to establish certain rules of its own, fine, but make them clear, make them easily accessible, so people can check or at least be informed what kind of behaviors are expected of them. Same with Article 14 and 15. Okay, what should be in the notification? And if there is a decision, okay, you are informed about this decision, and you are also informed about a possible redress mechanism. I think that is something that, from the perspective of fundamental rights, is very, very relevant addition. What else do I have to say?
Does any of the speakers immediately want to react to these statements already, or? Yeah,
if I may, Jacob,
yeah,
just to continue this absolutely interesting line of debate about if these platforms are regulators, to which extent they self-regulate. Completely agree with you, Aleksandra, that when I use the term self-regulation, I am referring to how they create a self-regulated environment. And as you said very well, where the users, so the community of users, has to be subject to that particular terms and condition policies and internal community rules. And that's, I think that is the key point, because Article 12 that you refer again in your comment, Article 12 is critical, because it's indeed, on the one side, is a natural acknowledgement that these platforms, these providers, are simply exercising their own party autonomy. They are concluding contract with the users, those contracts according to which the user joined the platform. So I completely agree with that point, that is critical, Article 12. But at the same time, beyond that, Article 12 is accepting that these platforms are regulators. And because of that, they are setting their own rules. The rules are going to be the standards for the purpose of reacting, following this procedure that Christian has explained so clearly. So just to add that that comment totally aligned with your remark. Thank you, Aleksandra. Thank you, Jakob.
Yeah, is there a further comment, or otherwise we have as well already a question in the Q&A session, or Ms. Kuczerawy, do we want to proceed?
I will maybe just quickly throw in a bunch of thoughts and then let's see where they take us. So I think in terms of Article 13, transparency reports, that's also very important addition. And I think what is also interesting is that that's not the only provision on transparency reports. It comes back, and I think it's Article 23 for online platforms, which come on top of Article 13, and then Article 33, I believe, for the very large platforms. So it's kind of like this process that depending on the role, the obligations change. I think that's good because obviously this is not an easy topic and we need evidence to make decisions on how to approach it, how to regulate it. But what I am missing in the DSA is maybe transparency reports also from the states in terms of what kind of information they request platforms to take down, because I think we kind of need information from both sides to have a full picture. So that's in terms of Article 13. Article 14, I will just say one thing. I very much agree with everything what Christian was saying. For me, what's interesting is that it seems that having a notice with the information that is listed there in 14.2 automatically leads to actual knowledge or awareness. So for me here, there are two issues with that. First, that would mean that basically any kind of notice that is compliant with those requirements will lead to a takedown because the platform will otherwise have a problem with, will lose the immunity. So that for me is still incentivizing overbroad takedowns. So that's one thing. Another thing, I think the directive was very much, well, there was criticism that it is not clear what's the difference between actual knowledge and constructive knowledge. So the actual knowledge or awareness of facts and circumstances. And that is in the directive, that's a difference in terms of when we talk about the threshold for criminal liability or civil liability. And DSA does not seem to clarify that. Everywhere that actual knowledge is mentioned, it's actual knowledge or awareness. So that is still something that is that might be creating confusion. And I think I'll stop on this. I did have some thoughts as well about Article 15.
For Professor Twigg-Flesner to reply to this, and there is also a question in the Q&A session to you, addressed to you. Maybe you can answer this as well, and then we will go back to the question for Professor Rodríguez de las Heras. Yeah.
Thank you. Yeah, I mean, the point about Article 14.2 and the impact on Article 5 is a really interesting one, because you're right. I think there is the danger of automatic takedown in many ways because of the concern about being held liable for the content that's now suddenly deemed to be within the actual knowledge of the hosting services operator. And in fact, to me, it seems to be a bit of a double lock on this, because as well as the express provision tying this to Article 5, there's also, of course, the point I made earlier, this reference to the diligent economic operator, which gets us all the way back to the L'Oreal judgment, where the Court of Justice says, well, if there is information which would cause a reasonable diligent operator to identify this as illegal, then Article 14 under the e-commerce directive is no longer available. So it's really kind of making quite significant inroads potentially into Article 5 and the protection Article 5 is intended to offer. And therefore, this is a concern that as soon as you get a notification, you will almost automatically at least disable content and then see what happens next. And if there's no complaint, then fine, no big issue. But then you might actually be faced with the second level of internal complaints about information which has been at least disabled, if not taken down altogether, out of fear of being held liable through Article 5. And on the database, well, yes, of course, databases do create more transparency and more clarity. But I'm just concerned that the volume of data this database will hold will rapidly become unmanageable. This is whole. I mean, in consumer law, we've been complaining for years about too much information being thrown at consumers, and we're talking still about relatively small items of information. So I think that it depends on how the database is structured, how it's going to be managed, what sort of possibilities there are for accessing the data and running some algorithms on it that maybe give us some more valuable information. So if this is just about creating a huge data set that does not much beyond that, then it will depend on what happens to that data and who can access it and who can do something with it. So yes, it might be a way of increasing transparency. It might be a way of getting a better understanding of what really goes on. But I think we need to know more about the design of that database and who can ultimately make use of that data and perhaps make use of it in a more meaningful way. Thank you.
Thank you very much. Yeah. Then I will hand over again to Professor Rodríguez de las Heras, and a question with you has been if you think there has been or there should be a distinction between recipients of service on the one hand and consumers and traders under the final text of the DSA.
Thank you, Jacob. Thank you for the question posed by the attendee. It's a very good question because that reveals that in the DSA there is an evolving terminology that may seem confusing sometimes, but it's simply representing this multi-tier structure that the DSA is based on. Recipient of the service is the umbrella term. Is this umbrella term that described this absolutely abstract relationship between the provider, intermediary service provider, and the user, not the recipient of the service. When we scale up and we go to hosting services and then platforms and then big platform or large platforms, now this idea of the recipient of the service is not enough to describe what is happening within the platform. And that is the reason why in this horizontal relationship, the DSA need to use the transactional terminology and need to talk about trader or business user in the case of the regulation, need to talk about consumer or user, consumer user in the case of the regulation. So why is that? Because here, and that is the reason why I like so much to use that drawing about the platform, there is indeed two different relationships. There is a vertical relationship that is the one between the user or recipient of the service and the provider. And this is the one that the DSA tried to govern on when is using the term user or recipient of the service. And then there are a multitude of horizontal relationships that are the ones that are negotiated and concluded between the user of the platform. So the trader that is already the user of the platform, but is the trader vis-a-vis the consumer, vis-a-vis the user. So even if the idea might be a little bit confusing, this terminology is indeed necessary for the multi-tier, for the multi-layer structure that the DSA is based on. Thank you, Jacob, and thank you for the question as well.
Thank you, yeah. Then there is one short question, maybe someone want to answer this very briefly concerning Article 44 and the corresponding annual transparency. Yeah. Does anyone have an answer to this?
If I may, very briefly, probably the question is more addressed to Aleksandra when she make a reference to the need of transparency reporting obligation on the state. But if that is the question, definitely this activity report is in a way the transparency mechanism implemented for the purpose of providing transparency through this new authority, this new procedural mechanism that is the Digital Services Coordinator. So I would say simply that unless Aleksandra, you disagree, I think that could be linked to your comment. Thank you, Jacob.
Yes, sorry, I was actually scrolling to look specifically at this article. I think indeed that might be a way. Yeah.
And also, if I may just quickly add, of course, if there is a decision made to restrict or remove access to information, Article 15 requires that the kind of reference to the database includes whatever reason was behind it. That may well be down to an Article 8 request as well. And therefore, the information to some extent will already be part of this wonderful database, which is going to emerge.
And if I may very briefly, we could connect as well with Article 13, when in this report, you have to identify the number of illegal content removed by orders. So that would be the other side of the information that we need. Thank you.
Thank you very much for your answers on this. And yeah, since time is already a little bit behind the deadline of our today's conference, do you have anything more to add, which needs to be discussed right now? If it's not the case, then I can thank you again for very interesting presentations. Thank you again for Ms. Kuczerawy for your comments on both speeches. And yeah, maybe a few concluding words from myself on today's episode of the conference. We had a very great introduction from Catherine and Sebastian on the emergence of the two acts, and followed by also very interesting presentations on the aspects of the DMA, which rather clear commitments that it is not more of the same and rather constitutes more a revolution, although it's based more or less on very traditional policy decisions, which has been noticed, and that the DMA in certain aspects could be a little bit, go a little bit further, also especially regarding to remedies. Then we had the second session where the DSA Act was compared to the already existing e-commerce directive, and where we talked about the problematics of the liability of providers for illegal content, and especially if we regard to hate speech and content moderation. And yeah, I also think that our session was very interesting, very lively debate. And on this point, I would like to draw your attention to the session of tomorrow, and then there will be a virtual network break on GatherTown before the panel discussion tomorrow. So you will get further information on this and the link also sent tomorrow. Then the sessions tomorrow are starting at 1 p.m. again, and also therefore you will receive the invitation link separately tomorrow again. So it only remains for me to thank all the speakers and also the participants for their questions on behalf of all the organizers of this conference, and say goodbye for today, and hopefully see you all again tomorrow with more interesting presentations.